You open your stall on the forum while the morning air still carries the scent of olive oil, cloth dust, and voices calling across the crowded passageways. A man stops in front of you. He does not ask the price of the goods on your table. Instead, he brings up an old debt of your father's, right there beneath the turning eyes of strangers and the fragile honor that can crack under only a few spoken words. You answer that such a promise was never clearly stated. But he does not argue from memory. He points instead toward the law code displayed openly in the square, where anyone may know it, invoke it, and compare it. It is there that Rome placed a limit on the distortions of memory, on hidden privilege, and on the way the powerful might interpret every matter to suit themselves. From a market stall to family property to the buying promises of ordinary people, law kept daily life from sliding fully into arbitrariness. And if you would like to go further with this question of why Rome placed the fate of its society upon a foundation of law, subscribe to the channel and join this journey. After the moment when law was brought into the light of public space, what the Romans gained was not an age of complete justice, a standard against which things could be measured. Before that, many judgments still rested on unwritten custom and on legal memory preserved in the hands of a small, educated, and well-placed group, and precisely where memory was monopolized, power often clothed itself in the appearance of tradition. The 12 Tables, traditionally dated to 451 to 450 BCE and regarded as the earliest written foundation of Roman law, did not abolish aristocratic privilege or patriarchal structure, yet their public promulgation narrowed the shadowed space of arbitrariness. For common people, the first value of law sometimes lay not in victory, but in knowing that their dispute would pass through a path that could be anticipated. Looking more closely at the 12 Tables, we see a distinctly Roman quality, turning everyday frictions into a structure capable of functioning. The surviving fragments, known through later quotations, show that the Romans were not pursuing only an abstract idea of justice. They were especially attentive to procedure, debt, property, inheritance, and agreements, the very places where life is most liable to crack. As many scholars emphasize, this code was not a liberation in the modern sense. It affirmed many existing arrangements while also reflecting a growing commercial society in which contracts and wills had become important enough to require a written framework. That sobriety is what gives Roman law its durability, unadorned, yet effective. They understood that a community stands only when even its smallest collisions have names, procedures, and a place in which they can be addressed. From the square and the magistrate, the flow of law moved into the Roman household, where society itself was arranged as a miniature model of public order. There, patria potestas was present, the authority of the head of household over children and descendants in the male line, including those adopted into the family. In Roman legal tradition, that authority was once so broad that the father became the central axis of representation in many private legal relations. Even the property a child was permitted to use remained, in principle, under the household's legal shadow. To modern eyes, this is a heavy form of power, but in Roman logic, it was also a means of binding responsibility. The family, therefore, was not only a refuge of affection, but a legal economic unit in which obligation, property, and honor were tied to a defined axis of authority. But a society cannot stand firmly on family alone. It must also stand on trust between people who share no blood. It is here that Roman law enters the domain of property rights and obligations. That legal tradition later developed the concept of ownership with striking sharpness, while also opening an entire world of obligations arising from contracts or from harmful acts. What is remarkable is that the Romans did not allow agreements to drift through the dim region of moral ambiguity. They gave promise a legal form, so that rights and responsibilities could be established, transferred, and claimed. When jurists distinguished contracts and delict, and when later legal compilations gathered, arranged, and clarified those distinctions, we see a society that understood this clearly. Order does not begin with speeches, but with the clarity of obligation. Markets, credit, property, all endure only when promise is upheld by law. Imagine that you are a potter on the outskirts of Rome. You have delivered the full number of oil jars to a merchant, yet payment keeps being postponed, and promises change their tone with each market day. In that frame, what do you claim to acquaintance, goodwill, or an order that allows you to name an obligation in legal language? It is in such small situations that Roman law reveals its practical and profound nature. Forms of agreement such as stipulatio, with its tightly structured question and answer form in the classical period, show how early the Romans sought to turn speech into a verifiable binding force. They understood that when the most ordinary transaction is placed within a formal frame, social trust no longer floats entirely on memory or kindness, but can stand on structure. And from such small bargains, the civilization learns how to govern on a larger scale. From household and marketplace, Roman law expanded onto a larger stage, the city as an integrated whole of civic life. What made Rome endure was not only the monument still standing today, but also its ability to place governance within clear norms and forms. When we speak of the Lex Julia Municipalis, associated with Caesar and traditionally dated to 45 BCE, we touch a layer of administrative thought showing that the Romans did not see the city as a spontaneous crowd, but as a body requiring offices, sequence, and order. Behind streets, councils, public duties, and local orders stood a consistent principle. If power is to endure, it must be framed in procedure. Here, law does not merely appear after conflict. It moves ahead of disorder, shaping the daily rhythm of communal life. And this is the point at which law becomes an art of organizing life, not merely an instrument of adjudication. If the city is an integrated whole of civic life, the legion is the backbone of Roman power, and both share a single principle: order must be bound. Legion is not only the name of a large military unit. In Roman history, it is the emblem of an entire framework of conquest sustained by organization, rank, and discipline. Within that military world, sacramentum carries a meaning beyond ritual. From a legal religious term, it binds the soldier's oath to the sacred dimension of obligation. Thus, Roman military strength cannot be separated from a culture of norms. The sword may open the way, but only discipline, repeated in training, formation, command, and oath, allows the war-making apparatus to move through campaigns, generations, and frontiers. Here again, law does not stand outside power. It is the very skeleton of power. Then there is water, a quiet element, yet one that decides the breathing rhythm of the city. Later generations often gaze at Roman aqueducts and marvel at the arches, the gradient, the art of guiding flow. Yet the Romans understood that infrastructure does not live by building skill alone, it lives by governance. When Frontinus was appointed curator aquarum under Nerva, and into Aquis recorded not only information on water conveyance, but also matters of control, distribution, maintenance, and supervision, we see that spirit clearly. A densely populated city cannot rely on spontaneous goodwill to protect its water supply. It needs authority, responsibility, and rules. It is here that law appears as the invisible component of the art of water management, not on the face of the stone arch, yet keeping the flow moving in rhythm across generations of inhabitants. And for that reason, water administration in Rome was both a practical craft and an art of rule through law. As Rome moved beyond the bounds of a relatively homogeneous political community, law had to learn to speak to a wider world. Merchants from afar, allies, inhabitants without Roman civic status, people who still needed to exchange, contract, and seek fairness within the same field of power. Out of that need, ius gentium gradually emerged as a body of equitable norms used in relations between foreigners and Romans. Later, jurists also connected the concept with what natural reason establishes for all. This did not make Rome an egalitarian society in the modern sense, but it reveals a central truth. An empire that seeks endurance cannot rely solely on the privileges of one group. It must create a legal language flexible enough for many communities to trade, dispute, and coexist within a common order. From here, Roman law began to assume the scale of a legacy beyond its own age. From ius gentium, the story of Roman law opens onto a deeper insight. An empire cannot endure by coercive force alone. It must cultivate a shared habit in a way people expect justice. For this reason, alongside statutes and decrees, Roman jurisprudence grew through the patient labor of jurists, interpreting, classifying, refining concepts, and linking individual cases into an order that could be understood. Here, law is no longer lines of text standing motionless in the square. It becomes a living language, tight enough to preserve discipline, flexible enough to move with a life always in motion. What made the Romans distinctive was not that they had disputes, every society does, but that they patiently built bridges between dispute and judgment. A vast empire can function only when countless small collisions are brought back to a common legal frame of reference. Yet order is tested not only in the courtroom or the marketplace, it is also tested in a place far more sensitive, the raising of money for the state. Taxes, fees, provincial revenues, war expenses, public works, salaries, all of it compelled Rome to establish a fiscal order that was both effective and controllable. In that setting, the publicani appeared as public contractors in the Roman world. They undertook construction, supply, and especially the collection of certain taxes under contract with the state. This arrangement brought flexibility to a government expanding rapidly, but it also opened the door to abuse, for wherever there is power to collect, there is always temptation to overstep. Thus the story of the publicani lays bare a distinctly Roman paradox. The state needs private actors to operate on a large scale, and for that very reason, it needs law all the more to ensure that delegated power does not slide into invisible exploitation. Look more closely at the publicani, and one sees why the Romans could not regard law merely as a moral emblem. When public tasks, especially revenue streams with fluctuating returns, were placed into contractual forms and cyclical auctions, the state was already bringing public finance into a procedural order rather than relying only on personal loyalty. That structure gave the empire the capacity to mobilize quickly across a space spanning many provinces. But at the same time, it demanded the opposite, a legal framework clear enough to define rights, obligations, responsibility, and limits. When law grows dim, people feel taxation as the naked will of the stronger party. When law stands in clear view, even fiscal burdens are placed within an order that can be named and invoked. And there, the difference appears between rule by fear and rule by legal order. If taxes are the bloodstream flowing into the treasury, then the collegia are the capillaries that keep the rhythm of communal life nearest to ordinary people. In the Roman world, collegia could be trade associations, religious associations, or burial associations, small yet durable bonds in which people found mutual aid, identity, and a form of communal dignity amid crowded urban life. What is striking is that many collegia operated as organized bodies capable of holding property and conducting affairs collectively, even though imperial authority later regarded them with a certain suspicion. A subtle Roman trait emerges here. Even within an order famous for its top-down direction, the state still had to leave room for networks of association rising from below. Law, therefore, was not only for repression, it was also for recognition, shaping, and limiting the sphere of collective life in Roman communal existence. Imagine a late afternoon in a crowded quarter of Rome. An artisan has just died, his family is not well off, and the funeral, if arranged on their own, could become an unbearable burden. Suppose you are the eldest son in that household. How would you manage without an association network, without pooled contributions, without a community to share in the final rites? It is in such deeply human places that the collegia appear not as a minor historical detail, but as a component of social order. Many Roman associations were tied to occupation, religion, or burial, and though the state often regarded the right of association with suspicion, their very existence shows that the empire understood a basic truth. If rule through law is to endure, society must also be able to organize itself within a frame. Here, law does not extinguish community. It draws the boundary within which community can endure. From the collegia, we glimpse another deep layer of the question. Why was Rome so dependent on law? Because the empire did not govern territory alone. It governed connection. A great city cannot stand merely by commands issued from the center. It needs countless intermediate institutions, households, local councils, associations, public contractors, military units, and each must know what may do, how far responsibility extends, and how it will be judged if it crosses the line. That is why Roman law often appears so dry as to seem almost without emotion. It is carrying out the quietest yet most necessary work, assigning roles within a society too large to run on improvisation. The more Rome expanded, the more it needed law not only to judge after disruption, but to prevent disruption from becoming the habit of public life. Then, after centuries of accumulating decrees, administrative practice, and juristic commentary, Roman legal tradition itself faced a problem of its own. Too fast, too scattered, too difficult to grasp. A civilization that had used law to resist arbitrariness now stood at risk of being clouded by the very mass of its legal materials. When Justinian I came to the throne in 527 CE, the law of the Eastern Roman Empire existed in a tangled condition between layers of old and new norms, not merely a difficulty in the revision of texts, but a crisis in the ability to foresee. And as we have seen from the beginning of this journey, that very ability to foresee was one of the central reasons Roman society held so tightly to law. Thus, the work of revision and consolidation under Justinian was not merely a scholarly undertaking. It was an effort to restore the intelligibility of order. Out of that need emerged what posterity calls the Corpus Juris Civilis, the later name for the body of legal works compiled under Justinian's patronage in the 6th century. This was not simply a new law code in any simple sense. It was an effort to select, arrange, and distill earlier enactments and the opinions of major jurists, while also creating foundational reference texts for the study and practice of law. What is worth reflecting upon is this. At the far end of this journey, Rome returned to its earliest instinct, to draw law out of dispersion and place it into a form that could be read, studied, and invoked. From the 12 tables traditionally linked to the mid-5th century BCE, to the Justinian compilations of the late Mediterranean world, one continuous current of thought runs through it all. Order endures only when law is form. The influence of the Corpus Juris Civilis reached far beyond the reign that produced it. Later European legal tradition, especially from the 11th century onward, developed upon the reception, interpretation, and adaptation of the Justinianic inheritance together with many later layers. And this, in turn, illuminates the central question of this documentary. Why was Roman society so dependent on law? Because for Rome, law was not only a means of resolving present disputes, it was also a way of preserving governing wisdom across time. Stone may collapse, borders may shift, dynasties may fade, but when a civilization knows how to crystallize its organizational experience in legal forms that can be taught, that civilization continues to live in later centuries. Rome left posterity not only monuments, but a way of thinking about order. So when we look back across the whole axis of law and order, we no longer see Roman law as a dry layer of text laid over life, but as an invisible frame supporting an entire world in motion, from household to marketplace, from legion to city, from water supply to taxation, from small associations to the multi-ethnic frontiers of empire. The Romans relied so heavily on law not because they naively believed law could make human beings perfect, but because they understood a more mature truth. When society grows large and interests overlap, only rules that can be named, arranged, and invoked can keep power from drifting wholly into arbitrariness. And in that sobriety, Roman law became a legacy not only of the past, but of every civilization that has wished to turn strength into enduring order. From the vantage point of the earlier sections, we can take one further step into this documentary's central question. In Rome, law was not only used to arrange power, but also to train the political imagination of an entire society. The Romans gradually became accustomed not only to asking who is stronger, but then asking who has authority, under what procedure, within what limits, and before which office. That habit of questioning, dry in appearance upon the page, was in fact a profound civilizational achievement. It gave people a point of support amid the uncertainties of public life. In the rhythm of long shadows cast by colonnades and the echo of texts read before magistrates, law taught Roman society to distinguish between personal will and an order that could be invoked. And once that habit took root, the empire was not governed by command alone. It was organized through a shared language of rights, obligations, and limits. Of course, that legal language never distributed protection evenly by modern standards. The Roman world was still built upon tiers of status. those with civic rights and those without, the free and the dependent, men and women, center and province, each legal doorway opening to a different degree. Yet for that very reason, the Roman story becomes even more worthy of reflection. A society could be deeply unequal and yet deeply dependent on law. For Rome, law was not first of all a promise of absolute equality. It was an art of governing difference on a large scale. They used law to define status, allocate rights, bind obligations, and keep those boundaries, however strict, from drifting entirely with the temper of those in power. The lesson here is not comfortable, but enduring. Rule through law does not mean complete justice, yet it can still restrain the volatility of power. And so, when we walk among the ruins that remain today, a stretch of basilica foundation, a weathered inscribed stone, a broken waterline, what remains is not only material. Behind the stone lies a habit of ordering, recording, classifying, publishing, invoking, storing, revising. The Romans did not only build roads so that legions could move swiftly, they also opened invisible roads by which public decisions could pass from dispute to judgment. They did not only bring water into the city, they also brought authority and responsibility into forms that could be handed down. It is that parallel movement, material and legal, that gave Rome its distinctive endurance. An arch may fall, but if a society preserves the art of ordering by rules, it can build again. In Rome's legacy, law often lies within the invisible design of the structure itself. To the modern observer, especially in societies that take pride in constitutions, courts, and frameworks for checking power, Rome evokes a feeling at once familiar and distant. Familiar because we still recognize the strength of procedure, records, authority, and legal language in preventing shared life from breaking apart. Distant because Roman order was built upon tiers of status that modern conscience can scarcely accept as a norm. It is precisely this coexistence that makes Rome such a useful historical mirror, not to copy and not to mythologize, but to see a truth more enduring than any dynasty. When communities expand, interests overlap, and power stratifies, societies always need rules that can be named and tested. Rome did not leave a perfect model. Rome left a vast place of tempering, where order itself was forged. Imagine a morning in Rome from the perspective of a local official, petitions to be recorded, land disputes awaiting classification, public obligations to be summoned, ledgers to be reconciled, and beyond the doorway a continuing stream of footsteps striking the stone. Suppose you were seated behind that table. What would keep your authority from hardening into emotional reaction before each face, each voice, each pressure? It is at that level of repeated work that law appears not as symbol, but as the rhythm of governance. Procedure is not always beautiful in the eyes of those who wait, but without procedure, power easily becomes moot. For that reason, documents, sequence, and authority compel power to pass through a frame before it touches the lives of others. From that vantage point, we also understand why Roman jurisprudence later placed such weight on the art of distinction. Distinguishing between ownership and possession, between status and capacity, between a moral promise and a legal obligation, between judicial authority and the private wishes of the office holder. These conceptual boundaries are not the game of scholars standing outside life. They are fine instruments for reducing confusion in a complex society. The more people, the more transactions, the more layers of status, the more society needs precise language to prevent conflict from spreading simply because a relation has been misnamed. In that sense, Roman law is both an art of thought and an art of preserving peace and shared life, giving conflict boundaries, names, and pathways, and thereby preventing it from being enlarged by ambiguity. Yet perhaps the deepest strength of Roman law lay in this. It compelled both state and society to accept something often difficult to bear, the slowness of form. Reading a petition, determining status, following the proper sequence, invoking the proper authority, waiting for a step of verification, all this could make contemporaries impatient, especially when interests were heated and disputes close at hand. And yet that slow rhythm was often the price required to keep power from taking shortcuts through justice. In the slow-motion film of history, many orders collapsed not only because they lacked strength, but because strength no longer consented to pass through form. Rome understood that paradox well. Legal form was not an ornament of power, but the brake that kept power from wearing down the very foundations of its own rule. Even so, Roman history also reminds us that no order preserves itself solely by the prestige of the past. Law needs those who enforce it. It needs scholarship to interpret it. It needs institutions to sustain it. It needs a political culture that respects limits. When those things weaken, the same text can be read in a different spirit, the same procedure can be used as a veil, the same authority can slide into private advantage. For that reason, Rome's legacy should not be seen as a closed storehouse of answers, but as a grave invitation to observe how a civilization once tried to turn strength into order, and how that order had to be continually nourished lest it become hollow. In the slanting light over the ruins, the greatest lesson lies in the patient labor required to keep law worthy of social trust. If one had to distill this journey into a single image, it might be neither sword nor crown, but an inscribed stone set where people pass. From the 12 tables in traditional memory to the vast compilations under Justinian, the Romans repeated the same civilizational gesture, bringing rule out of shadow, giving it form, giving it language, giving it the capacity to be read and invoked before a community. That gesture did not erase all injustice, nor did it heal every ambition. But it created something more enduring, a standard standing outside the immediate will of the individual. It is that standard, fragile yet recoverable, austere yet preserving life from drifting into arbitrariness, that helps us understand why Rome relied upon law as a mental architecture of empire. As we leave the axis of law and order, we may look upon Roman ruins with different eyes. Not merely as stone, arches, roads, water, or the names of distant offices, but as the traces of a persistent effort to answer a question that has lost none of its weight. How can a large society avoid being torn apart by its own weight? Rome's answer was not perfect, nor without blemish, yet was deep enough to outlast centuries. Name power, bind power, arrange power within forms that can be learned, taught, and amended. Thus in the Roman world, law was not only the voice of the state. In its best moments, it was a promise that shared life would not be wholly abandoned to the volatility of the strong. And then after passing through household, tribunal, legion, water, taxation, and the small associations of everyday life, another question quietly rises among the ruins. What happens when a society has grown accustomed to living within a legal frame, but that very frame begins to change shape? The history of Roman law does not move in one unbroken line. Within that tradition itself, alongside written law, stood other layers of norm, from decrees and procedural practice to the edicts of magistrates, continually adjusting the way justice was carried out. Britannica emphasizes the role of edicta and of the praetor in shaping judicial practice, showing that Roman law possessed both the backbone of tradition and the capacity to adapt to changing life. And in that very coexistence, preserving form while changing instruments, Rome reveals the depth of its organizing genius. Within that scene, what deserves notice is not only the text, but the way texts continue to live. A rule, if it lies only on stone or in a scroll, is not yet order. It becomes order only when someone with authority invokes it, when there is procedure by which it can be applied, when scholarship can interpret it, and when a community is familiar enough with legal language to place hope in it. That is why, in Roman tradition, magistrates and legal procedure held so great role. They were the place where law left the page and entered life. Britannica on Roman legal procedure shows that the forms of adjudication and the powers of the magistrate changed over time, yet the enduring point remained the same: the need to place disputes into a form that could be followed and invoked. Law, therefore, is not only the content of a norm, it is also the art of orderly execution. Imagine a moment very small, yet decisive. Two disputing parties stand before one vested with authority, each carrying a different story, a different memory, and a different grievance. Suppose you were the one required to judge in that setting. What did you rely on so that authority does not become bias draped in the robe of judgment? It is at that point of tension that Roman tradition shows why form, authority, and precise legal language were necessary. Not because form is always just, but because without form, justice easily dissolves into the feeling of the moment. Roman law, with all its historical limits, still persisted in creating a plane upon which disputes could be translated from the language of anger into the language of rule. And that was no small civilizational step in the history of organizing power. Yet just when we begin to see that strength, we also begin to see a subtler fracture. If law can be used to bind power, power can also learn to use law to legitimize itself. Roman history, especially in its later periods with layers of norms piled high, and ever more massive administrative apparatus, shows that legal order is never secured by the prestige of the past alone. Britannica on the age of Justinian describes a confused legal landscape of old law and new law before the great work of revision and consolidation, a sign that even a civilization famed for legal statecraft could have its ability to foresee dimmed by its own accumulation. Thus, the Roman lesson is not only how to build law, but how to keep law readable, understandable, and worthy of trust. And perhaps it is here, at the edge between ruins and memory, that the Roman story comes closest to us. The Romans left posterity not only principles of property, obligation, and procedure, nor only a high achievement of revision and consolidation under Justinian. They left a question that has never fully closed. When a society grows ever larger and more complex, who will keep power passing through form instead of taking shortcuts through fear? If the 12 tables were once the gesture of bringing rule into the light, and the Corpus Iuris Civilis the gesture of gathering order out of dispersion, then what remains for every age is the far harder labor, keeping law a place in which the community still dares to place its hopes. And that is also where this journey has not truly ended. For behind law there is always another question waiting to be named.